Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we got a brutal ruling, and I do mean a brutal ruling, out of the Second Circuit last week. Now, it does create a circuit split, so theoretically this could be a good thing in the long run. But if you live in the state of New York, yeah, this ruling didn't do you any good because, you know, your background check that you have to go through just to buy a box of ammunition, yeah, you still got to go through that background check. We're going to talk about what happened in the Second Circuit. We're going to talk about something that's happening in the Second Circuit, and we're going to break down the ruling for you today. So today, let's spend a few minutes and let's talk about the Second Circuit upholds ammunition background checks. Okay, America, as you know, we talk about a lot of bad rulings here at Washington Gun Law. In fact, if it weren't for bad rulings, don't know if we'd even have a channel. The bad ruling that we're talking about today comes from a three-judge panel in the Second Circuit in the matter of New York State Firearms Association v. James. Now, although this is an appeal from a denial of a temporary injunction, and so we're still in an interlocutory phase, blah, 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 understand that one of the elements that the court is looking at to determine was the lower court correct in denying that injunction is, do the plaintiffs even have a chance of winning this lawsuit? And the court here, the three-judge panel of the Second Circuit, has definitively said, no, they don't, and for one simple reason, which is, well, the Second Amendment's not even applicable here. I'm not making it up. Now, a couple of little sidebars here on this thing. First of all, if you go back and you take a look at the ruling of the Second Circuit in National Association for Gun Rights v. Lamont on Connecticut's assault weapon ban, and then you take a look at this ruling, and then you compare that with a three-judge ruling on the exact same issue out of California's ammunition background check in the matter of Rody v. Bonta, a case where a three-judge panel of the Ninth Circuit actually threw that law out as being unconstitutional. The question we have to ask ourselves is the Second Circuit moving themselves into pole position to the gold medal stand, if you would, of the crappiest and most anti-Second Amendment circuit in America. And of course, many of you are going, wait, yeah, that's right. Rody v. Bonta, the Ninth Circuit actually threw this law out. How is it that the Second Circuit can uphold it? Well, in the Second Circuit, you see this issue doesn't even implicate the Second Amendment. This is how the Second Circuit ruled on this issue. We hold, on this record, plaintiffs have failed to meet their burden of demonstrating that the ammunition background check provisions meaningfully constrain their ability to keep and bear arms under the first step of the Bruin framework. As such, we have no occasion to review the district court's historical analysis at the second step of the Bruin framework. Now, you see, the lower court had actually gone through a very long, mildly intellectually disingenuous historical analysis and determined that, oh no, we had a rich tradition of regulating firearms in this instance. So how can the history justify it? Well, it's real simple, because once you get to the Second Circuit, you don't need to get to the history because the Second Amendment's not even implicated. The ruling of the court is, on the merits, plaintiffs argue that the district court erred, including that they had not shown a likelihood that the challenged law is supported by a well-established historical tradition of firearm regulation, which is a requirement for success on the merits of their constitutional challenge. However, we need not address the district court's historical analysis because we affirm on a different basis. Namely, that plaintiffs have failed to demonstrate on this record that the modest conditions the ammunition background check provisions impose on the commercial sale of ammunition meaningfully constrain their right to keep and bear arms. So in addition to that rather, troubling and offensive ruling from the court, I want you to understand that even though in the summer of 2022, we thought we did away with balancing tests when Bruin came out, not in the Second Circuit. Thus, regulations on the means of acquiring, transporting, and storing firearms only implicate the text of the Second Amendment if they meaningfully constrain the right to possess and carry arms. But of course, what is meaningful? Well, that's going to be in the eyes of the beholder, or worse yet, in the eyes of those wearing the black robe. So balancing test gets re-injected back into it in the Second Circuit. They double down on it right here. A law regulating the means of acquiring firearms and ammunition does not meaningfully constrain the right to possess arms unless it is so restrictive that it threatens a citizen's right to acquire firearms and ammunition. Mere inconveniences do not constitute such a threat. And they further their point by stating, In other words, the Second Amendment does not elevate convenience and preference over all other considerations, nor does it guarantee a certain type of retail experience. So because of that, what the Second Circuit three-judge panel is saying here is, hey, the plaintiffs have not even proven to us that the Second Amendment's in play here, that it's even implicated. And we're going to uphold the ruling on those grounds and those grounds alone. As they put it, applying those principles here, we conclude, on this record, plaintiffs have failed to demonstrate a likelihood of success in showing that the challenged ammunition background check provisions implicate the plain text of the Second Amendment as required under Step 1 of the Bruin framework. Show of hands, how many of you believe that a right delayed is a right denied? Well, those of you who raised your hand, you're correct, except, of course, if you live in the Second Circuit, because they have ruled, in short, the modest delays reflected in the present record do not meaningfully constrain plaintiffs' ability to keep or bear arms. Well, as you know, these background checks aren't free. In fact, there is a monetary fee for each and every one of them, so they're essentially attaching a cost to what we believe is the exercise of a right, correct? Nope, not in the eyes of the Second Circuit. They have ruled. Under previous case law, a government-imposed fee in the Second Amendment context is constitutional only if the fees, 1, are designed to defray and do not exceed the administrative cost of regulating the protected activity, and 2, do not place anything more than a marginal, incremental, or appreciable restraint on an individual's Second Amendment rights. Once again, fully injecting balancing back into the equation, despite the fact that there's pretty clear Supreme Court case law that says we're not supposed to be doing that. Now, with all of this in mind, and knowing that the Ninth Circuit has struck this law down, the three-judge panel of the Second Circuit sees New York's ammunition background checks this way. In sum, none of the challenge provisions, individually or collectively, meaningfully constrain an individual's right to keep and bear arms so as to implicate the plain text of the Second Amendment. Because plaintiffs have failed to demonstrate that they are likely to succeed at the first step of the Bruin framework, we have no occasion to engage in the historical analysis at Step 2. And so with that, the three-judge panel of the Second Circuit has upheld New York's ammunition background check. Now, Rody v. Bonta, which was a successful challenge, is pending a full en banc petition by the state of California out there in the Ninth Circuit. Don't even get us started about all the gamesmanship that can go on here. There likely is going to be a petition to a full en banc panel of the Second Circuit as well. However, that may turn out to be an exercise in futility, especially when we track some of the more recent rulings from the Second Circuit. Okay, the case once again is New York State Firearms Association v. James. We're going to link up the ruling down below so you don't have to take our word for it. You can geek out on it for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.